Welcome to You Can Win in Court. Sometimes it's not enough to be innocent. The legal system is complex, and occasionally the innocent are wrongly accused. Here we will discuss in layman's terms the nuances from real court cases to provide insights on how you can best prepare to get a fair chance in court. Please note that the discussions here are not intended to substitute for legal advice. Please seek the advice and help from a lawyer regarding any legal matters. And now, please welcome your host, Dr. Petra Dieter.
Welcome, and today we are going to be talking about auto accident, and we have a very special guest with us today. We have Jeremy Hogan from Hogan and Hogan Law Firm in Orlando, Florida. Hi, Jeremy. How are you?
I'm great. How are you? Thanks for having me, Ms. Dieter.
No, thank you. Thank you. I know that you have a very extensive experience in this. So could you please give us a little bit of background about your experience?
Sure. So, in the 90s, I was a teacher for 2 or 3 years, and I figured I had done my time, and my father was a lawyer. So I decided to go to law school. I actually went to law school in Costa Mesa. I think you're in California, right?
Right. Yeah. So
Yeah.
that's not far from here.
Yeah. So I went to law school in Southern California there, and I graduated in 2002, 2003, sometime around there. And I practiced in California for a couple of years before moving out here to the Orlando area. So I've been practicing law here in Orlando since about 2005. So I've been a practicing lawyer for about 18 or 19 years. The last 8 or 9 years of which I've done mostly auto accident, personal injury, that type of thing, insurance claims. For a couple of years before that, though, I was doing all sorts of things. I was doing some criminal defense work. Almost anything. We're doing a lot of bankruptcy again because of what's going on in the world. But I find that personal injury is a very fulfilling practice, and you can really help a lot of people. So that's my background, and I really enjoy being a lawyer. It's really been great for me, for my family, and I think it's very fulfilling if you do it correctly.
Right. So we're talking about vehicle accident, which is something that we don't get to be prepared, right? It happened. That's why it's called accident. So before we even talking about getting into the courtroom, now this thing just bam happened to you. Obviously, you're in shock. You're probably seriously hurt. You might be or not, or maybe you're the cause of it. What are some of the things that you should be prepared before we even talking about going into court?
Yeah, that's a great question. It really is. So the very first thing you need to think about is insurance, of course. And a lot of people, unfortunately, have insurance that protects other people, and they fail to purchase insurance that protects them. And the particular type of insurance I'm thinking of is what's called under or uninsured motorist coverage, or for short. And if you have the typical insurance, you have insurance that will pay if someone else gets hurt or if someone else's property is damaged. And people don't think to buy insurance that will actually protect them. And actually, one of the big things that we see that people make a mistake is they buy insurance that protects other people, and they don't buy the insurance that protects them. So if you get hit by someone who only has $10,000 of insurance and you're seriously hurt, you're not protecting yourself. So that's the first thing, I think, is make sure that your insurance coverages are correct. The second,
that's even before you get on the road.
Right. Like right now, look at your insurance right now and make sure you have what's called coverage, and it could really save you a lot of heartache later, and it's not really that expensive. So talk to your insurance agent. The second thing is, when you're in an accident, there are certain things that we can't go back and fix later if it's not done at the scene. And most people aren't talking to a lawyer at the scene. You don't usually think to pick up your phone and call a lawyer, which is okay. I mean, that's not typical. But there are certain things that I can't go back in time and do because I wasn't there at the scene of the accident. So at the scene of the accident, the most important thing is to document everything. And nowadays, it's great because everyone has a cell phone. And so it's really easy for people to, snap some picture. 20 years ago, it wasn't, you weren't usually carrying around a camera with you everywhere you went. So you need to take pictures and get all and get the names of people that are there that were possible witnesses. Those are the two things that I wish people would do that I can't go back and kind of fix after the fact. So I think the main two things are, one, have your insurance in line right now, and two, if you are in an accident, you need to take a lot of pictures, because sometimes those pictures are the key to the case, and you need to get names of any possible witnesses. Those are the two things after an accident.
That's really great. And I think I should point out that you're practicing in Florida, so most of the discussions are probably going to be specific to Florida. But what you have talked about so far are really, really, you can apply it to anywhere, right?
Yeah, auto accident laws don't really vary. I mean, there's little variations between states. I'll give you one just quick example. So in Florida, when we go in front of a jury, we get to show the jury the whole bill from the hospital, for example. And look, there's $100,000 hospital bill, and we get to put it up in front of them, and they get to see $100,000 hospital bill. In California, that changed a couple of years ago. Apparently, I haven't practiced in California for a while, but now you can't show them the $100,000 hospital bill. You only get to show them what insurance actually paid. So that makes a big difference in a case. Here we can show them $100,000. In California, you'd only show them the $20,000 that the insurance company actually paid. So there are little things like that that are differences between the states. But in general, auto accident law, negligence law is pretty standard between all of the 50 states.
Okay, so now that, unfortunately you got involved into an accident, and, if you're smart enough and listen to this and, got your video camera out, like your phone out, and, take video and ask witnesses, and then so what's next?
Well, there's usually 2 or 3 parts to any auto accident case. Surprisingly, the thing that people usually call us about, especially in Central Florida, because we don't have very good mass transit here, is how am I going to get to work tomorrow because my car's in the shop and I don't have the car and I don't have the money to pay for a rental, or I don't even have a credit card. What am I going to do? So honestly, the very first thing most people call us about is not, oh, my neck hurts, or how can I get $1 million from this accident? Most people call us because they want to get to work the next day and they don't know how to do it. So that's the very first thing. So usually the very first thing in an auto accident case is to deal with the property damage. And that's what that's all about: getting the car fixed, getting a rental car while it's getting fixed, and taking care of those issues. That's the very first thing you want to do. But from a practical standpoint, the way you do that is you get the other person's insurance information and you report the claim to your insurance company. You should probably be reporting it right away, or even at the scene after you call your wife or your husband or whoever. That would be your next phone call. Probably be your insurance company to report the accident. And your insurance company will usually have people that will walk you through the steps in order to get your car fixed, make the claim, all that type of thing.
I see. And then, okay, so the next step is to let the insurance know, like your insurance company first, get the other party insurance, and then contact, and then what next?
Well, then there's a couple other things that are involved. So the next thing is, if you're injured, which is usually, our clientele is usually injured. If you're not injured, then it's just the property damage, and that's probably going to be about it, reporting it to your insurance company. But if you are injured, then we need to make sure that you're able to get adequate medical treatment, and that if you're not at fault for the accident, it really shouldn't cost you anything. This should all be done under either insurance, or, you're not at fault for the accident, you really shouldn't be paying anything out of pocket for any of your medical care. So the next thing we usually deal with is getting medical treatment for people. There's 2 ways to do that. In Florida, we have no-fault insurance. No-fault insurance is a child of the 70s. And the idea is you shouldn't have to sue someone in order to get medical care. So your own insurance pays for your medical bills. It's rare nowadays. We're one of only 11 states that still have no-fault insurance. Here we call it PIP. But in other states, they usually just refer to it as no-fault insurance. So in a no-fault state, whoever is at fault for the accident, your own insurance pays for your medical treatment. So in Florida, that's pretty straightforward. In California, it's a little bit more difficult because there is no-fault insurance. So what you have to do is you have to go to a doctor who's going to treat you on, here we call it a letter of protection. In California, they call it medical lien on the case. There are doctors that will treat you and you'll pay them when the case resolves or the case settles. And that usually means that you're going to have a lawyer because the doctors want to make sure that there's going to be some settlement to get them paid. So there's two ways you can get medical treatment: through no-fault insurance or on a letter of protection.
So you mentioned the word, is that PEEP or something? In Florida,
PIP
is
is,
it?
yeah, Florida has personal injury protection, and it's called PIP here for short. But
I see.
in the 10 other states, I think they just call it no-fault insurance.
I see. All right. Okay, so and you mentioned there are three prongs to this. So we talk about property damage and medical treatment. So what's the third one?
Well, the third one is what would be what most people think of when they think of personal injury lawyers, which is the settlement, right? So after an accident, if you're not at fault, the idea is to make you whole. And part of that is to make you whole for injuries you've suffered. Unfortunately, the law does not have a way to make people feel better. So the only way to compensate people is monetarily. So that would be the third prong, would be basically the claim against the at-fault carrier for damages for the injury. And that's when you get the law firms up there that are, advertising about how they got $500,000 for this person and $100,000 for that person. So it's property damage, medical treatment, settlement of the case. That's usually in a car accident, the three prongs of what we do from a legal standpoint.
And so let's just say if the other party, and let's say the other party is at fault and they have adequate insurance, and so would you expect, in a good scenario, is that, your lawyer, somebody like you, would just contact the other insurance and then things would just get resolved?
Well, in 90% of the cases, that actually is the case. The reason for that is that personal injury trials and verdicts are public record. So we know what a case like yours what a likely verdict would be for that case. The insurance company knows what a likely verdict for that case would be. So, over thousands of cases, we get a good idea for what the value of a case is. So the reason we can resolve 90% of cases is because we know the case is worth $20,000. The insurance company knows the case is worth $20,000. It's just a matter of everyone meeting at that point, from where they want to negotiate. So the vast majority of cases will settle. It's not as simple as a phone call. What we do is we have to wait until the end of your medical care because we want to see how everything resolves. Some people just have a pain in their neck, it goes away. Great. We get that case settled nice and easy. Some people, it never goes away and they have to go under the knife. They have a surgery. And that case, of course, is going to be, worth a lot more than someone whose pain is essentially resolved. But the bottom line is that we can get most cases resolved because there's so much information out there about what a jury will usually return a verdict for. The cases that don't resolve, usually one, there's a liability issue. So, it's not always as easy as you rear-ended me, right? So there's always some kind of liability issue or a he said, she said, kind of issue, or two people were merging into the same lane and they ran into each other. And so who's at fault? We don't know. Those cases can end up in court. The other issue is if we have a lot of pre-existing medical conditions. And so the insurance company knows that you were in an accident last year and you also hurt your neck. And then you're in an accident this year and you injure your neck again. Well, now there can be some, argument about what was caused by last year's accident, what was caused by this year's accident. And those are the type of cases that might end up in court. But I'd say about 90% of cases we can resolve without going to court.
I see. Okay, so before we continue, I would like to take a moment to thank one of our sponsors. So this episode is brought to you by Lawyer.com. Lawyer.com is the most advanced lawyer matching service, so users can get the help that they need by either calling the referral experts or fill out a referral form or search a very comprehensive directory of over 2 million lawyer listings. For a free consultation, you can also visit our website at vitalitas.com/winning. Thank you. So let's get back to Jeremy. So now we talk about, in a good scenario, we would be able to settle this outside of court. So what about if you get into a situation where, you can't get to that agreement? And then now you have to go to court. So I think you mentioned a few times about a jury. So is that always a jury situation, or is there Is there ever a situation where there's no jury?
Well, from the plaintiff side, from the injured party side, you're going to always want a jury, and you're never going to want a judge to make a decision. And in Florida, and I believe in California also, you have the right to a jury trial in almost all civil litigation. So a jury trial would be with 6 people. Um, the main thing that I think our clients don't understand, and before we file a lawsuit, we tell them this, is just how long these things can take. I don't think people understand. I think Judge Judy has kind of slanted the view on how trials work. So, you get this feeling that you file a lawsuit and then next month you're in front of the judge and you get to tell your story and, Judge, this is what happened to me, and now my neck is killing me and I can't get out of bed in the morning. And it's just not that way. Litigation is a long and grinding process. And here in Florida, we see some cases take 3 or 4 years to get to trial.
Oh my
And
God.
yeah, and I know California is the same. I had a case in California about 3 or 4 years ago, and we were on kind of the same schedule. The courts are just horribly backed up and they're underfunded. It's probably just going to get worse before it gets better. And we have a case that's set for trial in next month, actually, and it's going to be kicked to next July. So just like
Oh,
that,
because, yeah.
yeah, I mean, this is a case we've been litigating for 2 years now. And we thought,
Wow.
okay, now we got our trial date. And, COVID-19 happens, and now we're pushed back to next summer, if then. So
Wow.
I think people don't understand how long a process it is to get to a jury trial.
Uh, 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 to be honest, I'm completely shocked. I had no idea that it was going
Yeah.
to be 3 or 4 years
And
to
expensive
get to
too.
trial. Yeah.
Yeah, and expensive too. Our last trial, which was last year in November, I think was our last trial for the firm, cost about came out to about $60,000 that we paid to get that case to trial. I'll just give you one
Wow.
example. Yeah, we had an orthopedic surgeon was our witness, and the orthopedic surgeons make a lot of money. So when you ask an orthopedic surgeon to take the day off to come and testify at court, that's not cheap. That's thousands of dollars. So, every witness that we use is thousands of dollars. And
Oh
that's
my
money that
God.
we front on the case. But I think people are always surprised by how long it takes and how much it costs. So you're looking at a 2 to 3 year trial process and about $40,000 to $50,000 on a typical car accident case.
Oh my God. So that is just to get to trial. So what about that whole process? How long would it take and what does it look like?
Well, when you get to trials, actually, that's the fun part. It's getting there that's hard. So
I see.
it's a 6-person jury in Florida, and I believe in California also. It could be 9. It's been so long, but it really is kind of what you see on TV. I mean, once you get in front of the jury, a typical car accident case usually is about a 4 or 5 day jury trial. Everything takes long because anytime you're going to have any argument, you have to have the jury get up and go back to the jury room, and you make your argument, then you bring them back in, and there has to be constant breaks for people to use the bathroom and this and that. There's objections to testimony, and when someone objects, then all the parties have to walk up to the judge, and she turns on this noise so that the jury can't hear what you're saying. You make your argument to the judge, she makes her ruling, and then you walk back to the podium. And so the whole thing can take a long time. It's fun, but it is kind of a grinding process. For the lawyers, I enjoy it, but it is very tiring. If we do 4 or 5 jury trials in a year, that's a lot for us. When you're in jury trial, you have to shut everything down. You wake up, you're thinking trial, you get home, you're preparing for the next day. So it's about 1 week where you cannot work on anything else other than that case. And
Wow.
in the week, about 2 weeks before the trial, you also are basically focused on that case as well. So it's very demanding to do that. And there are some attorneys that can do 1 or 2 trials a month, but I don't know how they do it. I can't do it. I don't have the stamina, to be honest. So it's very demanding, but it's also very there's nothing like it in being a lawyer than a jury trial, because then you get to the end of the trial and you're sitting there and the jury comes out and they read the verdict, and there's nothing like that moment in life where you're waiting to see what the jury's going to do.
Wow. So how, like, what are the things that you? I mean, obviously there's a lot. You've got 3 or 4 years, so there's a lot of work that come up to that point. But can you point out to some of maybe bigger things that people may should definitely look out for, or things that they really very often overlook in the preparation?
You mean for lawyers?
For yeah, for no, for the cases, for the, I guess,
Oh,
the people that involved. Yeah.
yeah. Well, a jury trial is all about preparation. And to a very large extent, the case is won or lost before you even walk into the courtroom for the trial, right? So every the thing you have to remember is, and this is why it's so demanding and so very, you have to be really on point because every fact that you have to prove, because as the plaintiffs, we have to prove everything. The defense can just sit there and say nothing and they win. So we have to prove everything. So every fact that you have to prove has to be supported by one of two things, either a witness, words, or a document. And the witness's words sometimes are not allowed into evidence because you have the hearsay rule. So I'll just give you a quick example. Um, let's say you're in a car accident and we want to get into evidence that it costs $5,000 to fix your car. Let's just say. You can't walk into court and say, it costs $5,000 to fix my car. You have to have firsthand knowledge of that. That would be hearsay because that's what someone else told you, right? You could say, I paid $5,000 to the body shop, but you can't say what was done and why it cost $5,000. So when you're thinking about getting ready for trial, we have to think ahead to all of these things. And I have to know that you're not going to be able to testify to that fact because that would be hearsay. So I know that I have to bring in the auto body shop owner or the mechanic who did the work because he has firsthand knowledge of it. So every little fact like that, you have to think, how am I going to support that fact? How am I going to get that into evidence? With documents, it even becomes more difficult because you can't just show up with, let's just use that auto body example, with the receipt from the auto body shop and hand it to the judge and say, here's the receipt. It's not that simple. Every document that you use to support any fact has to be substantiated and authenticated. Someone has to say, this is the receipt. And they have to be there because the other side has the opportunity to cross-examine them. So, you have to think of all these things ahead of time. So for that one fact, let's say we just want to prove that it costs $5,000 to repair your car. I've got to come up with a witness and I have to make sure that that document is authenticated and substantiated by the witness so that I can get it into evidence. So it really becomes a matter of just organization. And the organization you basically want to use is you list all the facts that you have to prove one by one, and then you list which witnesses you're going to have testify about it and what documents you're going to have to support it. And then from there, you have to go down and, then you get into little mini details about it. But the overall picture is witnesses and documents and how you get them into evidence and how you get that testimony into evidence. And then during the trial, you're going to have the fight about whether, whether the evidence is sufficient and those type of things. So I think if you're not planning for your trial months ahead of time, you're planning to lose because you can't just wake up a month before trial and start planning at that point. And it's too late. So,
Wow. I mean, a lot of people, like me, that are not, we are not meant to be spending time in court if you're not a lawyer. So I think a lot of people underestimate what you just said, particularly about evidence, because, for example, I didn't realize that, like you said, you just think that, okay, clearly this is a receipt. I paid it. I can even bring my, let's say, credit card statement to match, right? And
right.
you would think that, and this is clearly a bank statement. It has a bank stamp on it, and it has the mechanic shop logo and nothing. I, as a normal human being, would think that, well, like, what else to be questioned about this? Is clearly, I paid it. I know I paid it, and it's real. There's no, so and I mean, there's cases where even the police report is not sufficient, and I would have thought the police report would be it's a government document. It comes from the police. It like how much more official you can get, and yet somehow it's still considered hearsay, which is
think of the judge as the gatekeeper of evidence. So the judge gets to make the decision on what the jury sees, and then the jury weighs the evidence. But as the gatekeeper, the judge knows the law sometimes better than you do. So you better be ready with all of your, points on point. But I think lay people like you, they have that same feeling, like it is what it is. I brought the paper, and why can't you see it? But literally, if you don't have that authenticated, the judge will not let the jury even take a look at it. And actually, you could get in trouble if you even show it to them. So those are the things that that's really why you have a lawyer involved. Now, small claims court is a little bit different, and they have a little more lax rules. Like you might be able to get away with bringing in just the receipt and just showing it to the judge. But if you're not in small claims court, then you're expected to know the rules of evidence and make sure you get all your evidence into evidence through the judge.
So what about, you talk about, get your phone out and film things. How is that video, like, can you actually use that video as evidence? And how good is that as an evidence, and the likelihood of being able to enter that?
It's great. It's great because if you're my client and you took the video, well, obviously at the trial, you're going to be there. So the way you would get that, let's say you take a picture of the scene of the accident. So this is how that would work. So I would put you on the stand. Of course, you're the plaintiff. Usually you would testify first. And then I would say, Ms. Dieter, were you in an accident? You say, yes. Did you have your phone? Yes. Now, mind you, we can't show the picture to anyone yet. So what I have is I have 3 copies of the picture at my table, okay? Because one's for the judge, one's for the other attorney, one's for you to show you. So then I say, Ms. Dieter, did you take a picture of the scene of the accident right afterwards? Yes. Then I take the picture and I walk up to you with it, still not showing the jury because they're not allowed to see it yet. I hand the picture to you. I say, Ms. Dieter, is this the picture you took at the time of the accident? You say, yes. Is this an accurate representation? Yes. Did you take this on your phone? Yes. Is this the full and complete picture that you took? Yes. Then I say, Judge, may I approach? I give the picture to the judge. I give 1 copy to the other attorney. The judge says, I say, I'd like to enter this into evidence as exhibit whatever. And then the judge asks the other attorney, do you have any objections? So you have authenticated the picture because you've testified that you took it and that it's an accurate representation of the picture you took. So that's all you needed to do. So having my client having taken the picture makes it so much easier because I don't have to bring anyone else into the courtroom. So then the judge will look at the picture. If there's no objection, she'll say, no objection, it is entered as exhibit whatever. Now it goes to a pile of papers of evidence that the jury can review and look at when they're back deliberating the case. So that's how you enter something into evidence. And sometimes it's not quite that easy, but the example of a picture that my client took after at the scene of the accident would be really easy to get into evidence.
So, with today technology, people can get very creative and very, very good at photoshopping, for example. So that actually confused me because it seemed to me it would be easier to fake a Photoshop photos than a receipt or a bank statement. So that's strange. Let's say if the other party was bringing in a photo that you believe that is a fake photo, how do you prevent them from being able to enter that as an evidence?
That's a good question. So you know how we're talking about how it takes 2 or 3 years to get to a jury trial? That 2 or 3 years is spent doing what's called discovery. And the discovery process is where you get to ask the other side questions about their case and this and that. And they get to ask you questions. And sometimes the discovery process gets very contentious because, for example, if we have a suspicion that someone has doctored a photo, we're going to want to get access to their phone. And the court can literally order us to get access to their phone, and we can have a forensic computer specialist or phone specialist, I don't even know what they would call them, but review the phone and see what the original pictures might have been on the phone. Or we can get access to the computers and actually have someone go through the computer and look for all the old pictures, and they could, the forensic computer guys are really good. If you had a picture on your computer at one point and then you opened it up with Adobe or whatever and doctored it in any way, they will know, unless you're also a computer specialist and you know how to cover your tracks, I guess. So the answer to your question is, that's our job in those 2 years leading up to the trial, is to figure all that stuff out and make sure that there's no funny business going on like that.
Okay, so that's interesting because um, that was kind of answer part of my question that I had earlier, because you said, you go into court and then you present this picture or whatever. I would have thought that the picture would have been already submitted with your declaration at the beginning, but it seemed to me that you have not submitted you until in court. But at the same time, the other party has already been given the information of what you are about to submit. Is that right?
Yeah, so, well, that's a good question. So you've touched on something that's a little bit different, I think. So when you file your lawsuit, the complaint only requires nowadays a bare bone factual allegation. So you just allege things in your complaint. You don't usually have to attach any evidence. Now, in the next step in the discovery process, it's the other side's job to ask you questions and to get documents from you in order to fulfill their discovery obligations, right? Then at the end, when you're getting closer to trial, it used to be that you wouldn't have to give all of your documents until right before trial, but they've done away with that. Usually 90 days before trial, all documents that are going to be submitted for evidence to the judge have to be given to the other side. So they're trying to do away with that kind of, trial by surprise element. So your picture of the car after the accident would have had to been given to the other attorney 90 days before you even stepped into the courtroom.
I see. Okay, so that's called the discovery period,
Right.
the process. Okay, great. Okay, so you go in, and so is this entirely a factual based case? And I mean, are there any other things that you can help to improve your chances?
Yeah, so your damages in an automobile accident case specifically are your medical bills and pain and suffering. Well, medical bills, lost wages, pain and suffering. The most important of those is pain and suffering, because medical bills are medical bills, but how do you calculate? This is kind of the big question that we run into all the time. If someone's going to have, let's say they're going to wake up with a stiff neck for the rest of their life, whereas before they were in perfect health, how do you calculate how much money that's worth?
Right.
And there's no good answer for that. There really isn't. A jury looks at you and they say, well, I feel bad for her, I'm going to give her $50,000. Sometimes that's really the analysis. Or sometimes they think, well, I don't really think she's that hurt. I think she's faking. I'm not going to give her any money. So pain and suffering is what it boils down to. And our part of our job is to make our client look as good as possible, as human as possible. So we often bring in spouses and children to talk about how the injury has affected our client. And all of those things are things that you can do to maximize a personal injury case. Because in my experience, if the jury doesn't feel bad for my client, they're not going to award them enough money. Okay, so our job is to make our client presentable, likable, human, and to almost see if we can get the jury to be, feel their pain in a sense. So we'll often have our client talk about how, she used to be able to do this and now she can't do that anymore. She used to pick up her, 2-year-old all the time, but now she can't do it, and she feels bad because she can't pick up her child anymore. So those are the type of things that we really got to focus on if we're going to really maximize a case.
What about so you mentioned about lost wages and medical bills and all that. Is there some kind of possibility for punitive type of what do you call it?
Punitive damages?
Yeah, like is it showing example of how poorly this driver is? Is there such thing?
So it's possible. We usually don't get there in a car accident case because the truth is, honestly, that usually these are just accidents. People aren't paying attention. They get distracted. They don't realize that the car in front of them has stopped, and they run into the back of them. The general rule is, in order to get punitive damages, which are damages which are meant to punish someone, the act has to be almost intentional or grossly negligent. So the most famous punitive damage award, I believe, was, did you ever hear about the coffee cup, the hot coffee award against McDonald's?
Right. Yeah.
It was for some ungodly amount. I don't remember what we used to, they taught us that case in law school, but it was like $120 million. And what happened was the lady got coffee and she spilled it on her lap and she got burned and she sued
Yeah.
McDonald's and they awarded like $100,000 of damages and $100 million of punitive damages.
Yeah.
And the argument there was that McDonald's knew that coffee was scalding hot and it would burn people. And in fact, it had burned numerous people. You know, they knew that coffee was dangerously hot, yet they still continued to serve it. That was
Right.
the intent or the recklessness in their action. And
Yeah.
so her damages were only $100,000 because she ended up being okay. But the jury awarded punitive damages because McDonald's acted recklessly, and that was to punish. So how do you punish a company that makes $1 billion a year? You can't just hit them for $100,000. They decided in order to punish McDonald's so they wouldn't do something like this again, you hit them with $100 million, and that was the punitive
Oh.
damage. But we don't usually see that in our cases because they're usually just, regular old accidents.
So what if the driver, the person who caused the accident was, let's say, drunk or under influence of drugs, or perhaps the license has been suspended and yet they were still driving, and like what about that kind of situation? Is that the opportunities for you to look for this type of damage?
Yeah, but you just opened a can of worms because
Sorry.
no, it's okay. Because here's the issue. So, most people on the roads are not independently wealthy, right? So I'm sure Bill Gates isn't driving around in his Toyota Tercel, but John Smith is driving around in his Toyota Tercel on the road, and John Smith doesn't really have $1 million in the bank. So we're always looking for insurance money, right? Because most people are not collectible, meaning you could sue them and you could get a judgment against them, but how are you going to collect on it? He's got
Yeah.
$1,000 in the bank and he makes, $12 an hour working at McDonald's. So the issue always is we need to find insurance. And if someone does something intentional or reckless that would allow for punitive damages, the insurance companies don't have to cover it because you're not covered by insurance for intentional acts. So for example, you can't buy insurance that would ever protect you from shooting someone on purpose or punching someone in the face. It goes against public policy to let someone buy insurance to protect them from those sort of things. So every insurance policy will not cover something that's done intentionally. So if someone's out drunk driving, we tell our clients this all the time. Sometimes our clients call and they say, hey, I smelled alcohol in his breath after the accident. And I was like, well, let's, we have to be honest with the insurance company, but if they don't ask you about that, let's not mention that, because that actually could be a bad thing for us, because now the insurance company could deny the claim and that's really hurting you.
Oh,
So
I
you
see.
have to be careful about intentional acts in the realm of insurance, because if it's intentional, then you're going to have an insurance denial. And then you're looking at trying to collect against, John Smith and the 20-year-old Toyota Tercel. And that usually doesn't go very well. So.
Actually, so then that's a very good point to be aware of, actually. Uh, so from what we have been talking about, then I have a sense that, let's say if the other party doesn't have insurance, you almost don't have a case. I mean, you could win, but it's probably not going to be worth anything.
It's the most heartbreaking situation that I run into as a personal injury lawyer, is when you have someone that's really hurt and there's just no way you're going to be able to collect against someone. And you could file a lawsuit against most people on the street and you get a judgment against them for $1 million, but you can't get water out of a stone. What are you going to do with that judgment? It's just a piece of paper. And so we run into that all the time, especially in Florida. We have so many uninsured motorists running around here. And that's why the very first thing I mentioned to you when we started talking was to buy the insurance to protect you in that situation. Because we have a client who's in a wheelchair, and it's just heartbreaking that the guy that hit him didn't have any insurance. And so what do you do in that situation? What we're doing in our situation is you look for someone that is collectible. So you're always looking for deep pockets, and people think of that as a bad thing. And I could see where they're coming from. Why would you sue them? They didn't do anything wrong. Well, the reason why we're suing them is because otherwise I have a client who's in a wheelchair and I can't help him. So, in our situation, we're looking the highway department for something about a design of a road. But you never want to be in that position, because the truth is that the other driver caused the accident, and the Department of Highway might have contributed to it, but really the main actor here was the at-fault driver. So you never want to be in that position where you're trying to find kind of a secondary liability, but we often find ourselves in that situation. Or you have to let the case go, which is also difficult. I've had clients that are literally in tears when I tell them that. And I was just like, and I just have to say, you want to get a piece of paper that says they owe you $1 million. I understand, but it doesn't mean anything. What are we doing here? We're just wasting your time if we do this.
Wow. So if the other party doesn't have insurance and you do have the insurance, would you have to go through this whole litigation process, or would you be able to just then settle the case with your insurance easily?
Right. So insurance basically steps in place of the other party's insurance. So we actually settle a larger percentage of insurance claims than the other way around, because when you're making a claim, you're literally making an insurance claim. Let me back up. When you file a lawsuit in a car accident, you're not suing the other guy's insurance company, you're suing him. And then his insurance company steps in and defends him and pays whatever. When you're making a claim because the other guy doesn't have insurance, you're literally making the claim against your insurance company directly. And that makes all the difference. It's much easier to settle those cases, because when we file a lawsuit against John Smith, it's John Smith sitting there at the table in front of the jury, and the jury thinks that we're getting money from John Smith. When we sue State Farm, a representative for State Farm Insurance Company is sitting there in front of the jury. And so, of course, that makes things a lot easier, because the jury's not going to be worried that they're messing up John Smith's life. They know that State Farm has more money than God, so they're not going to worry about whatever verdict they're going to give. So because of that, we actually are able to settle insurance claims much easier than if it was the other party's insurance.
I see. Okay, cool. So is there anything else that we should talk about for people to prepare for these sort of cases?
I think we've covered a lot. I think the main thing is, going back to the beginning, is the main message here is look at your insurance policy, because it's really heartbreaking for what we do when someone is really hurt and we just can't help them. Or we're trying to find where we have some weird theory of liability against some other party. That's not a situation you want to be in. Make sure that you're speaking to the lawyer who's going to handle your case if you're in that situation. I think the big red flag is if you call a law firm and you are retained and you sign a retainer without ever having spoken to a lawyer. To me, that's kind of the biggest red flag that I would mention to people. If you're just talking to an intake person or a paralegal and they retain you, I mean, just think, don't you think that a law firm that really does a good job a lawyer is going to talk to the client before there's ink on the paper, right? So
Yeah.
That's the main thing I would tell people. There's some really good lawyers out there. There's some bad, but the main thing is to have a lawyer working on your case. And a lot of law firms will not even have you talk to a lawyer until weeks or months into the practice. I've heard stories about people who've had a whole case go through this settle, and they never even speak to their lawyer.
Wow.
Yeah.
So you actually answered what I wanted to ask about, like what kind of things you should look out for when you're trying to find a lawyer. So, if you don't talk to the lawyer, it's just definitely a red flag. But I mean, what else? How else do you figure out who might be a good lawyer for your case? Where do you look?
Well, Google reviews are good. But one little trick you might use is, if you have a car accident case, if you know a lawyer in town, even if he doesn't do car accident law, especially like Orlando is a medium-sized town. It's not a big city. All the lawyers kind of know everyone else. So if you call a real estate lawyer or a probate lawyer or anyone, and you say, who's a good car accident lawyer, they're going to point you in the right direction. Or if you don't know someone like that, you might just call your local, I don't know, family law lawyer. And if you can get them on the phone, which maybe that, that might be difficult to do. But I would definitely ask for referrals from other lawyers, because it's a small world and everyone knows who's who. And, you know, everyone knows who tries cases and who doesn't, you know.
I see.
So, and that's another question you might ask your lawyers. You know, did you try any cases this year? Have you tried any cases last year? Because if the answer is no, then the insurance companies also know that that lawyer hasn't tried a case ever. And I think you're going to get a lower settlement if that's the case. So I think that would be another important question.
Okay, cool, very cool. Um, yeah, that's so. Are we really saying
Sorry, I
that?
don't understand.
Oh, I'm sorry, my phone just decided to talk. Technology, right?
Siri
So,
jumped in.
yeah, so from what we were talking about, it seems to me that if you can't afford a lawyer, you may as well forget about this. You're not going to have a case. Is that true?
Well, you know, we work on, every personal injury lawyer works on a contingency. So we all work on a percentage of what we recover.
Oh, I see.
My practice is built around contingency work. Usually the people that can afford to pay a lawyer $300 or $400 are going to the big, you know, law firms downtown. Not to my firm, but we do a lot of work on contingency. We do bankruptcy work on a payment, but those are flat fees. So, you know, it's $1,500, you know, for everything for a bankruptcy. So it's not a large amount of money. And then in the car accident world, we do everything on a contingency. So if we don't recover for you, you don't have to pay us.
So that actually is a very good thing for clients, because they know that you are going to work really hard, because you're not going to make money unless if they win, right?
Yeah, you know, it's interesting. You know, sometimes we work on the contingency world is interesting for lawyers. And you know, the bottom line, the truth is that sometimes you basically send a letter. It's never this simple, but sometimes you send a letter and you make $5,000. Sometimes you can work on a case for years and spend $100,000 working that case up, and you lose at trial. And not only have you worked for free, but you've lost money, because our clients don't pay us back if we lose the costs. So it's a high stakes world, the contingency fee world, because it could be great or it could be horrible. You can make $20,000 in an hour or two, and you can spend years and lose $100,000. But the idea is to have it all even out at the end and be able to, you know, pay your bills and pay your staff.
So you just brought up something to me is kind of really important for people that trying to look for a lawyer, because obviously for you as a lawyer, you're gonna not pick every case. You're not gonna take every case that come to you. You're gonna be selective about that. So as somebody that got into an accident and need to look for a lawyer, what are the things that they should be prepared to present themselves to the lawyer to make sure that a good lawyer will take them?
That's a good question. So when you talk to a lawyer for the first time after a case, if you have a great case, you're gonna have no problem. All right. So this is usually this answer is addressed to people who have marginal cases where, let's say, a slip and fall case where, you know, you're not sure if there's going to be liability. Those cases can be kind of difficult. So you have to understand first off that the lawyer is going to be investing a lot of time and money into your case, and the big issue always comes down to two things: there's liability and there's damages. You have to show the lawyer and kind of prove to him when you're talking to him that the other side is liable. So it's not enough sometimes that there's just water on the ground, and you're at a store and there's water on the ground. I slipped, I fell. Most people think of that as clear liability. Well, it's not, because what did the store do wrong? The guy right in front of you, walking in front of you, might have spilled that water on the floor. Did the store have time to even know that that happened and to clean it up? The answer is probably no. So you want to focus on liability first and foremost. Tell the lawyer why the store did something wrong, why they were at fault, right? So you can say, well, look, there was water on the floor. It was like dirty water. It had obviously been there for a long time, and the store should have known that it was there and should have cleaned it up and protected me from slipping and falling. And if you present it that way, it's much better than, I was walking, I slipped and fell on water, I want you to take my case. The second thing is damages. Lawyers, of course, are going to spend a lot of time and effort on your case, and we weigh a percentage. So we really don't want to file a lawsuit on a case where the potential recovery is only $10,000, because we can spend 2 or 3 years on a case. We make $3,000. That's a losing proposition. You'll go out of business pretty quick. So if you want a lawyer to take your case, you need to kind of talk to them about damages. And then the final thing is you want to make sure you don't forget about collectability. So when you're talking to the lawyer, you might think you have a great case. This guy messed up my car, but the lawyer's thinking, is there insurance here? Is there any money we're going to be able to recover? So, I'm not sure exactly what the conversation would be, but if someone hit you in a car accident, for example, what a lawyer wants to hear is it was a 2015 BMW, or the guy was driving a Mercedes, or whatever the case is, to show the lawyer that there's something there that could be collected against, versus a 30-year-old, Toyota Tercel, which I used to drive, by the way. I have nothing against Toyota Tercels. They're great cars.
Thank you. So thank you so much. So we talk about so many things today so far. I mean, we talk about, even before you're getting on the road, getting the right kind of insurance, make sure to have insurance to cover when the other person doesn't have insurance. We're talking about when you get into an accident to make sure to collect evidence and getting witnesses and everything. We talk about, property damage, injuries, and settlements, how you would want to have jury in a case, and then we're talking about it could take a long time, like 3 or 4 years, and making sure that we prepare the right kind of evidence and making sure it's credible and that it's going to be able to enter so that the jury can actually see the kind of evidence that you wanted them to see, right? We talk about the discovery period. I mean, we talk about so many things. I think we talk about the burden of proof is on the plaintiff. Is that right?
Right.
And then we talk about how most of these cases are contingency. So when you approach the lawyer, make sure to keep in mind that, there's liability, there's damages and collectability, so that the lawyer will see that this is a potentially a productive case for them to take on, right?
Exactly.
This is a lot and it's really helpful. So Jeremy, I mean, tell us a little bit about your personal life, and I think I know that you and your wife started the firm, right? And then, so, I mean, other than work, what do you do as a person? I mean, what's your hobby or what are you passionate about?
Well, I have 2 children. So between work and the children, there goes all your free time, right? But I am a big Orlando City soccer supporter. We've been a big fan ever since they were in the lower league. I think that was 2010. So if there's a soccer game, you'll find me watching that. And that's really my hobby nowadays. I don't have too much time for anything else. At the firm, we've been kind of getting our bankruptcy department up and running again, because we kind of see that things are heading that way for next year, unfortunately. But it's a good practice. It's a practice you can help a lot of people. So I've been spending the last 3 or 4 months working on that. A lot of my friends and everyone were home and playing video games and watching TV all day. I was at the office hustling to get that up and running again. It's an interesting time right now in the legal world, because all the courts are closed and all the trials are getting pushed back. It's horrible right now in the legal world. The only thing I could say that we're coming out of this better is that we're doing a lot more of the Zoom hearings. And we used to go to these little hearings for, it's a 2-minute thing in front of the judge, and you would have to drive to the court, wait, get called in, judge, blah, 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 blah. The judge would be like, okay, she would sign it, and then we're done. We save all that time now just getting on like a Zoom call or whatever the court would use. So that's been kind of fun. But I'm sorry, I'm going back to work again. I'm a big soccer fan. I used to support the LA Galaxy when I was out there. But when I moved here, I was like, yeah, I'm not going to support them anymore.
I think that's a good thing for your client that you're a workaholic. I don't think they're going to complain.
Yeah. Well, nowadays I work on the weekdays, but the truth is I'm at home for dinner every night, and the law's been good to me. I met my wife in law school. She sat in the
That's so
front, I sat in the
sweet.
back, of the class.
Oh,
Yeah. And
stalker.
yeah. And then, we open our practice together. People kind of say, well, you know, and it is tough because you bring work home and we're talking about it all the time. It is tough, but it's a blessing, I think, um, to work with your wife because who can you trust more than your spouse, right?
Right.
Otherwise, I'd have, a partner and, you know, you may or may not get along. So, I know that my wife always has my back no matter what. So it's great to be practicing with her, and we've done very well. But I get into work at 8:30, but I'm home by 6 o'clock every night. I spend dinner with the family, and I have a 6 and 10-year-old, so we pour our energy into the kids really because they're the future, right? So
Of
that's
course.
that's where it
That's
should be
wonderful.
going. Yeah.
So, I think, well, I'll put in the show notes some of the ways that people can contact you if they wanted to reach out to you.
Okay.
So we'll probably get your website and all that. So thank you so much for being here and for really so much information, like very helpful. So thank you for joining us today. And if you have any questions or suggestions, please leave a comment on our website at vitalitas.com/winning. If you find value in our program, please subscribe, share, or leave a review. And also, you can also support us by becoming a patron on our Patreon page. You can find the Patreon link on our website, vitalitas.com. Thank you so much and stay wonderful.